All right, we are now recording. Today's webinar is Legal Considerations for Marketing Your Farm Social Media. Nicole Cook with the Agricultural Law Education Initiative at University of Maryland Eastern Shore is the speaker today. We are recording, and this link will be sent out to all the participants as well as having the slide set. So Nicole, if you want to share your screen, you can now do that.
Great. All right, here we go. Can you see that okay?
Yes, looks good.
Okay, great. Thanks, Shannon. Well, hello, everyone. I'm so glad to have this chance to talk with you today about some of the important legal considerations that you need to pay attention to if you're using social media to advertise your farm or your farm products, or maybe if you're even selling your farm products online. So I assume that everybody who's listening to this webinar is doing so because social media is either already some part of your farm marketing strategy, or you're starting to think about using it in your marketing for your farm, probably because people are telling you that you're going to need to be using social media to market your farm. And I know we have a poll that's running right now. I can't see the poll, but we're going to get some, I guess, the results of the poll in a few minutes, but we'll leave that up, I think, while I'm talking through the next few slides. And also, I just want to make sure, is there any part of the slide that's blocked out, Shannon?
No, it looks good. It looks
Great.
very good.
Great.
And whenever you want the poll, we've got, let's see, 3 people that have answered. So
okay.
if those logging on want to complete the poll, and then when you're ready, Nicole, just let me know, and we can let you know the results and close it. Super.
Okay. All right. We'll leave the poll open for a little bit more while I talk through all the lawyer stuff. First of all, okay, I am an attorney, so you're going to get a disclaimer. I am going to talk today generally about the law, but please understand that I'm not giving specific legal advice this afternoon. Even if I might answer specific questions, or you might hear me use an example of a problem that might be like one that you're maybe experiencing on your farm, you, of course, are always going to need to consult a private attorney who can evaluate your particular circumstances. But if you're shopping for an attorney, I want to let you know that the Ag Law Education Initiative, or ALEI, does have a list of attorneys that are in the Delmarva area, and it's located on our website, and that is www.umaglaw.org. So it's umaglaw.org under our Legal Resources tab. And that directory actually lists the states that the attorneys are licensed in, as well as their specialty areas like tax law or trust and estates, or like you might be looking for in this instance, business or commercial law. So I'll tell you a little bit about ALEI. ALEI is a collaboration between the University of Maryland Francis King Carey School of Law, the College of Agriculture and Natural Resources at the University of Maryland in College Park, and also the School of Agricultural and Natural Sciences at the University of Maryland Eastern Shore, which is where my office is located. And at the bottom of the slide is the information about where you can find ALEI online. So we are, of course, on social media. We do have a website. Again, that's umaglaw.org. We have a Twitter account, and we do tweet. We also have a Facebook page that you can like and follow us on. And we also have an email, and we do check that email inbox. So if you have questions after today's program, please feel free to send an email, and you will definitely get a response. We also have an information line for people to call, and that number is 410-706-7377. Again, when our legal specialists aren't going to give you specific legal advice, but if you need legal help, we can certainly direct you towards available resources and attorneys that are in your area. Also, we have a risk management blog, which you can access from a link on our website, and I do post there about farm marketing issues. And I'm actually going to recommend taking a look at the blog post here that's titled, "Be Careful What You Like on Social Media." And I wrote that about how your Facebook page or your website could be viewed as an extension of your product label, and how liking claims that someone else might post on your page, but which make unsubstantiated health benefit claims about a product, could land you actually in hot water with the Federal Food and Drug Administration. Also, I want to make sure that people understand that my slides will be made available to anyone who wants a copy. I think Shannon will post them on the Women in Ag website, and also you can get them directly from me as well. And all of the links that are in my slides are hyperlinked, and that'll take you all to the information that's discussed in the slide. And I'll try to point out other instances of hyperlinks in the slides. Okay. So I was in Portland, Oregon last October at a symposium for agricultural lawyers, which is a real thing. And I was at a session on key legal issues attorneys should know about new agriculture. By the way, new agriculture at that time meant issues involving alcohol production, agritourism, and bringing farmers to work under H-2A and H-2B visas, none of which I thought were particularly new to agriculture, but nevertheless. What I heard during that symposium was these statistics. I heard that in 2015, farmers sold over $8.7 billion of edible food commodities directly to consumers, retailers, institutions, and a variety of local food intermediaries like distributors or wholesalers. And that consumers accounted for approximately 35% of those direct food sales, which was about a little over $3 billion worth of food sales. That involved 69% of the farms with any direct sales. And those direct sales came through farmers markets, farm stands, CSAs, pick-your-own operations, but also online sales. So what those numbers told me was that the internet is getting to be an already very crowded place in which you are having to compete and get noticed. And that might mean that you feel pressure to post things fast without vetting them, or to respond immediately to a negative review that might be posted without considering the consequences. All of which could mean, of course, big headaches for you if you infringe on someone else's intellectual property rights, or you wind up in an online spat with the customer. It also means that your competition is also susceptible to doing the same things, which might mean that you end up having to spend a lot of time protecting your own intellectual property rights. That's why it's important for you to know how to spot the potential legal risks associated with online farm marketing so that you can avoid those traps for the unwary. All right. Do we have our poll results?
Yes, so we will close the poll. And are you already using social media? We had 2 that said yes, 3 that said no. Facebook was definitely the highest. We had 4 on Facebook and 2 on Twitter.
Oh, okay, great.
Yep.
Well, that actually, that's interesting. I usually get a lot more hands that say that they're already out there using the social media, so I'm really pleased to have people thinking ahead, of course, and people who are already using it and they want to dig in and dive deeper into the protections that they need to have in place. And yes, Facebook and, did you say Twitter?
Yes.
Okay, Facebook and Twitter seem to be popular. I guess Instagram might be falling maybe into 3rd place. Sometimes I know you had a list up there, and sometimes people, I see them using Snapchat. As you all know, there's a variety of platforms that are being developed, and people are trying to find creative ways to reach out and use all of them. Just know that the information that we talk about today really does apply across all of the different platforms, the social media platforms. That's everything from websites to the more interactive platforms like Facebook or Twitter. So for the folks who are already using social media to advertise their farm, if I had you here in the room with me, I'd love to ask how many of you have someone in your operation whose job it is to review the content on your website or your Facebook page or your Instagram feed, just to make sure that you're complying with the advertising laws, the copyright laws, the e-commerce data privacy laws, etc. And my guess is, based on other audiences, that I wouldn't see a lot of hands go up. My guess is that, like most everybody else in the world, the majority of people who are listening to this webinar really think that the World Wide Web is pretty much just the wild, wild west, and anything goes online, and also that there really aren't any rules, let alone anyone watching what's happening online. But in fact, the internet, and especially social media, can definitely feel pretty lawless, and it can feel like a free-for-all a lot of the time. But the laws of the real world do apply in the digital world and the virtual world, and you do need to adhere to those rules and regulations, especially if you're advertising or selling products online. So what I'm going to cover today are the common legal risks associated with online marketing, how to avoid them, because no farmer I know has time for a lawsuit. So again, I'm a lawyer, so of course I like rules. I just wanted to point out that everything that I'm going to cover today can really be distilled down into these 3 things on the left that you always need to keep in mind, and these 3 things on the right that you can do to protect yourself. So if you remember nothing else from this webinar, remember these rules of 3. The first is the 3 main areas that you want to pay attention to as you're looking into your social media marketing plan are the intellectual property issues that I'll talk about today, the privacy and data collection protection responsibilities that you have, and also then the rules and regulations of the Federal Trade Commission and other consumer protection bodies that have to do with advertising. And then, I have to move something here so I can see it. And then you want to think about the three main things that you can actually do to protect yourself from falling into those traps. And the first is to know the rules. It's certainly easier to break the rules if you just pretend that they don't exist, but now everybody here knows that they do exist, so you need to make sure that you're cognizant of what the rules are. You don't want to end up in litigation, and nor do you want to end up in, again, some kind of online dispute, especially in an arena like social media where news travels really fast. The basic rule is always use your common sense. So rule number 2, use your common sense. If you don't want somebody posting something about you, then you wouldn't post it about them. That includes your competitors or people who might need to leave negative reviews. And if you're ever worried about clicking send or post, there's probably a reason you're worried about it, so I would recommend you don't do it. And the last rule to protect yourself is always attribute, always quote, always cite, always link. Just do as much as you possibly can to identify the creator of any non-original material that you might use in your marketing and your advertising. Social media laws relating to who owns the content that's being shared, when it's being shared, where the sharing is appropriate, and what limits might be imposed on the sharing raise a whole host of issues relating to trademark or copyright infringement that we'll talk about, social media marketing, labor relations, in fact, even, and much more. So again, make sure that you're always doing proper attributions, quotations, just as much as you can to identify the creator of any non-original material that you might use in your marketing. So let's start by talking about those intellectual property issues. So the best way to avoid getting sued is to ensure that you don't infringe on the intellectual property of others. Intellectual property is any product of the human intellect that the law protects from unauthorized use by others. Intellectual property is traditionally comprised of 4 categories that I'm sure you've all heard of: patents, copyrights, trademarks, and trade secrets. Trademark and copyright infringement are the risks that are most connected with using social media. And slip-ups can happen, even to the most sophisticated companies. In fact, this slide is an example of an instance where a sophisticated company, a sophisticated corporate entity, Duane Reade, made a costly mistake when it decided to tweet a picture of a celebrity and tag her using her trademarked professional name without her permission in order to promote its stores. So in this case, it was Katherine Heigl, and she sued Duane Reade for $6 million when they used her trademark, which was her professional name, without her permission. You should know that personal names can only be registered as trademarks if they've acquired what the U.S. Patent and Trademark Office refers to as secondary meaning. That means that celebrities can successfully seek trademark protection of their name in order to protect the financial integrity of their name as a brand. So their name translates into their fame and their brand. And in this instance, Katherine Heigl sued Duane Reade under the Lanham Act, which protects trademarks, like her name, her professional celebrity name. She also sued under the New York's state civil rights statute for protection of the use of her likeness for the purpose of trade. And that was, in this instance, Duane Reade trying to use her likeness for its own commercial gain. So again, not only did the judge, what seemed like a lighthearted tweet, land them in hot water, just socially speaking, and from perception point of view and PR, but it also turned into a costly lawsuit for them. So let's start with talking about what trademarks are. A trademark is an identifying mark that's used in connection with particular goods or services. A trademark can take many forms, including a word, a name, for instance, Nike, the name Nike. It could be a symbol like the Nike swoosh. It could also be a slogan, again, like Nike slogan, just do it. Those are all trademarked, protected by Nike. It could also be a device. It could be a sound, like the Harley-Davidson motorcycle sound that everybody is familiar with and can recognize right away as a Harley-Davidson. It could be a fragrance. It could be a color, like the Tiffany's blue, those Tiffany boxes that are blue. That color is actually trademarked as Tiffany's Blue. It could also be trade dress of a food product or package. For instance, the Toblerone chocolate bars, that triangle shape, that's trademarked. And the Coca-Cola bottles, the shape of the bottle, everybody knows that's a Coca-Cola bottle. That's actually a trademarked trade dress food product packaging. So when the trademark is used in commerce, it helps to distinguish the origin of the goods or services. The purpose of the trademark is actually to inform the public about the source of the goods or the services. So you use a trademark to build brand trust and loyalty, right? That's what makes the mark valuable to the holder of the trademark. And people look then for the mark because they identified some kind of quality, some appealing attribute of the product with the maker of the product, which they then associate again back through the mark. So that's the value of the trademark. And on the side there are some particular farm trademarks. And they would have trademarked everything from the actual name, for instance, Brookshire Farm, to the logo that's on there and the two of them appearing together, as well as maybe even the color scheme. So in order to avoid infringing on someone else's trademark, you just don't use their mark at all anywhere in any of your materials. That's the easy way to avoid it. Or you get their express written permission to use their trademark, which usually involves getting a license from them to use their trademark. And there can be reasons why you may want to use somebody's trademark. But if you are looking into using their trademark, first decide whether you must, and then if you do want to use it, getting a license from them and permission from them to use their mark is the recommended way to do that. Also, I don't want to see anybody get cute in trying to use a mark that comes close to someone else's, but not quite. You don't want to do that like New York's Coffee Culture Cafe did when it launched a coffee drink that it called the Frappuccino and then got sued by Starbucks, which claimed that the Frappuccino appeared too similar to Starbucks' trademarked drink, the Frappuccino, which Starbucks has said had an annual value to Starbucks of $1.5 billion. So you can bet that they were protective of that trademark. So again, we can't get too close to someone's trademark and try to cause confusion, which is what the law is trying to protect, is confusion in the marketplace. So that's trademarks. Now let's talk a little bit about copyright. So copyright protects original works of authorship, including literary works, dramatic works, musical works, and artistic works such as photographs, which a lot of people are going to be looking at wanting to use in their social media advertising. It also protects poetry, novels, movies, songs. It even protects computer software programs as well as architecture. What it does not protect is facts, ideas, systems, or methods of operation, although it may protect the way that those things are expressed. So a really good example is that recipes typically cannot be afforded copyright protection because a recipe is really a list of amounts of ingredients and the order in which to combine those ingredients. So the recipe is really, in fact, a fact and a method, which aren't protectable. But a recipe book, which is a compilation of recipes and which involves the author's ideas of how to express the information, like the choice in sequencing the recipes, the artistic work that might appear in the book, the choice of font, all the other enhancements like the stories that might accompany the recipes, all of that is able to be granted copyright protection so that someone else cannot duplicate that particular book of recipes, although they could take the information of a particular recipe and express it in a different way. So I hope that makes sense to everybody. The U.S. Copyright Patent Office, I wanted to point out at the bottom there on the right, the U.S. Copyright Office has a good booklet that explains more about what works may and may not be protected, and there is actually, again, that hyperlink there to the guide in the slide if you'd like to go into that. So copyright protection, which is granted in Article 1, Section 8, Clause 8 of the U.S. Constitution, was established to encourage creation by securing for a limited time to authors and investors the exclusive right to use their respective writings and discoveries. I think you need to understand that copyright actually attaches at the time of creation, the instance that the art is created or that the work is created. There's no requirement for filing for protection. There's no requirement even to use the C in the circle for the protection to attach. Copyright applies to both published and unpublished works as well. You should understand that. So it doesn't have to be a published work in order for it to be protected. It just has to be somehow memorialized. Copyright is actually a bundle of 4 exclusive rights that allow the owner of the copyright to do or authorize a number of things and exercise substantial control over her work. So it gives the author the right to reproduce the copyrighted work and to exclude others from reproducing the copyrighted work without, again, her license. It gives the author the right to display the copyrighted work publicly, to prepare derivative works that are based on the copyrighted work, and to distribute copies of the work. Again, and also to exclude then other people from doing those same things without permission from the copyright holder. So, in order to avoid infringing on someone else's copyright, before you use that picture that you saw posted on someone else's website or Facebook page that you loved, don't assume that it's yours for the taking just because you found it online. Even if it's a picture of your farm that was posted by one of your customers on her Facebook page. Many, if not most of the photographs are copyrighted and owned by the person who took the picture. Again, the copyright attaches instantly the moment that the work is created and memorialized, and if you didn't take that picture, you don't own that picture. And so, if you're not using pictures that you took by yourself, then by default, you're using work that was created and owned by someone else. And the general rule is that you can't use a copyrighted work without express authorization from the owner. There are 2 exceptions to copyright, however, that you should know about. One is that you can use works that are in the public domain. So the public domain applies to works, copyright does not apply to works in the public domain, and works that would be in the public domain would be things like words are not typically protected under copyright, so that everybody has a chance to use the words, of course. Proper names are not usually protected by copyright. Slogans or short phrases are not usually protected by copyright, but again, you might want to look into whether they're protected under a trademark law. Blank forms are not protected. Those are in the public domain. Again, that's usually the idea of that's an idea that can't be protected. Non-original works, so again, if this is not an original work, there's no protection. And government works are all in the public domain, so also including a lot of works that come through public universities. So remember that I said that copyright secures exclusive rights for a limited time? Well, something that you might want to know is that starting this year, for the next several subsequent years, there is going to be a big new crop of novels, plays, music and movies that are entering into the public domain in the United States. And this is because the copyright protections, which in 1998 Congress extended by an additional 20 years from the original 75 years, so now giving copyright protection to work for 95 years after publication, those are now expiring for works that were published 95 years ago, which was a particularly prolific period in the arts in the United States. So copyright has expired for all works published in the United States before 1923, and then every year thereafter, at the start of the next year, there's going to be more works that fall into the public domain. That includes just a multitude of works, including works by Virginia Woolf, Willa Cather, Robert Frost, F. Scott Fitzgerald, the list goes on. So you'll have a lot more material that's available for you to use that's in the public domain and that you can use freely. I think that's kind of exciting for marketing purposes. The other exception to copyright is fair use. And I do have a lot of information on my slides, and that's because I know that people will go back and they can get the slides and read through it in more detail. But just letting you know that fair use itself is a legal construct that allows people to see and share images in all kinds of media, but it's useful also for images that appear online. It is the exception or an exception to the exclusive rights that a copyright owner has. The purpose of the fair use doctrine is to allow for limited and reasonable uses for the benefit of the public, as long as that use doesn't interfere with the owner's rights or impede with their right to do with the work as they wish. So for example, if you're going to do like a product review, which a lot of people do online, they use a product, they want to give a review of it. Well, you could either take that product, for instance, and set it on your kitchen counter and take a picture of it and post that picture, and that's fine. But you can also, under the fair use doctrine, go to the website of the manufacturer And if you see an image that looks just like the image of the product that it would look like if you took it on your kitchen table, only maybe it's a little more polished, typically you can post that image that you've taken from the website and use it in your product review, and that will typically be deemed as fair use of that image. There are limits, though. You need to know that it's only a court that has a final say about whether your use falls within the fair use doctrine. And there's going to be scrutiny about how you used it. So, for example, again, if you're using it for criticism, for comment, for news reporting, for teaching, you might be using it for teaching, like we're doing today, scholarship or for research. All of those things are typically deemed to be within the fair use doctrine and not an infringement of copyright. So you want to look through that. But if you have any questions or doubts, I think I'm going to suggest, of course, that you talk it over probably with an attorney. There are also venues for using works of others in your marketing materials without infringing on the owner's copyrights, and that is through getting a license to use the works. And usually how this is done is, for instance, online in particular, for advertising, we like to use images, right? That's really important on Instagram and other platforms. And a lot of times what people want to use or will use are stock photos. So a lot of people are familiar with stock photos, and I think there's a lot you can talk with your marketing agents about what are good sources for stock photos, but a lot of times you'll see you get a subscription that gives you a license then to use photos in that particular stock photo service. And when you get the pictures, obviously it will come and you can use them without having that background that says whoever, iStock or whatever. The other source for licensed, kind of mass material is through Creative Commons licenses. If you're familiar with Creative Commons, there's actually some connections I'll show you later that you can get more information about Creative Commons sources for materials. Creative Commons is actually a whole host of a variety of different levels of licensing that are conferred on different media, images in particular. And what happens is you either agree that you're going to accept the terms of the license. Sometimes those terms can be the owner will allow anybody to use it in any format, wherever. Sometimes the license is restricted to only being used for non-commercial purposes. And that license usually is required to travel with the image. So if you agree to the license, that means that anybody that uses your intellectual property that you create using that image, for instance, that you've licensed, also has to agree to use it in the same way. And there is more information. I don't have enough time today to talk specifically through all of the different varieties of licenses. The Creative Commons is another common source that people use for material. So here's what it really comes down to. If you need to use another person's image, you need to get their written permission, if you can, or make very sure that your use fits clearly into one of the protected exceptions, the public domain, or the fair use doctrine, or you need to seek legal counsel if you've made a significant investment of time or money in your project and you really want to make sure that you're protected. Copyright fair use has been fought over when it comes to using words and images in print publication. The internet, however, is still very much in its infancy when it comes to fair use guidance. Without bright line rules from the courts, we're really left to interpret laws that were written long before digital communication was ever even imagined, and really don't contemplate the ease of sharing that exists today. So I really would encourage people who have questions or doubts to consult with an attorney. While it may be a remote possibility that you'll be sued for copyright infringement relating to an image, you do want to bear in mind that you may end up being the proverbial straw that broke the camel's back. You might be the 1,000th person or 10th to 1,000th person that's captured and used somebody's image and they've just had enough. And if you're considering taking images from large agencies' websites, or you're thinking that you'll just crop the image so you can't see the copyright notice or some other identifying information, I'm going to tell you that you're going to want to think twice about that. Large companies have legal teams that do nothing but look for infringing uses, as this company in Maryland unfortunately learned the hard way. Under copyright law, a successful plaintiff is entitled to elect between actual damages, which are lost profits and can be hard to calculate, or statutory damages. Well, statutory damages for infringing a copyright can be up to $150,000 per work if the copyright owner can demonstrate that the infringement was willful, meaning that the defendant knew that they were wrongfully using someone else's images. Or the copyright owner can get up to $30,000 per work if the infringement was merely negligent. Even if the defendant in that case proves that they really, truly didn't know that their use was infringing, the law says that the judge can only reduce the damages to $200 per work under the statute. Plus, a successful plaintiff is also entitled to recover the cost of litigating their claims, including their attorney's fees, which can be substantially more than the total actual or statutory damages. So these are all reasons to take precautions when you're using material that you suspect, that when you're using non-original material. Something else that I want you to know is that the terms of service or other similar guidelines that are posted on the platforms that you're using, like Facebook, Instagram, Twitter, which you'll see on here on the slide actually, I pulled up from Facebook and from Instagram, and those are their terms of services. Well, these platforms are private companies. They're not subject to the First Amendment censorship complaints. They can take down your page or your post if they determine that you violated their rules of conduct. And a lot of times their rules of conduct include that you're not able to post infringing material. Although it doesn't really matter whether you actually did, in fact, infringe on someone's trademark or copyright. They, under their terms of service and because they're private companies, they have a right to take down material that they find violating their terms of service. So you definitely want to make sure that you're familiar with the terms of service on the platforms that you're using for marketing. Okay, so we've talked about how to not infringe on someone else's marks or copyrights, but you also need to think about protecting your own intellectual property. If you're marketing or advertising, you're creating intellectual property, and you'll want to protect that. So let's start with how to protect your copyright. If you're using original marketing language on your material, you may want to seek to register your copyright for that text, and you can do that with the U.S. Copyright Office. And what you'll see here is actually a snapshot of the registration portal as it appears when you go into the web page. Again, those are links in my slides, hyperlinks that will take you there. It's fairly simple to do, but I also would recommend that if you have a lot of material or something that you think is going to be carried through for years or is going to be a big central theme of your marketing, etc., there are reasons that you may want to hire an attorney to make sure that you dot all your I's, cross all your T's, that kind of thing. Another way that you need to, or that you want to think about in terms of protecting your intellectual property is to make sure that you set out your intellectual property use expectations clearly in your terms of service. So most farms have a website, and usually that's a foray into online marketing. So on your website, and also posted in your other platforms where available, you're going to want to set out the terms that you expect other people to abide by when they're using images or text or whatever creative material that you might use in your own marketing online. Okay, so that's protecting your trademarks, how to get it registered, and telling people that your trademarks are, or excuse me, your copyrights are important to you and you want to protect them. Also, you want to know about how to protect your trademarks. Again, we're talking about you're probably going to be creating trademarks. You have most farms have names or logos. Those kind of things are trademarks. I'm not going to talk through all of this. The slide is going to be available. The links on the slide are available. Just understand that, again, if you're sending out marketing emails or contacting people with flyers or advertisements, you're probably putting out a brand or a logo that you want to protect. And you can register a trademark. If you look on the the right-hand side of the slide, trademark registration can take place at the federal level through the U.S. Patent and Trademark Office under the Lanham Act, or at the state level, and here I have a link to the Maryland Secretary of State, but whichever state you live in, you'll have, usually the registration will be done through that Secretary of State office. If your goods or service, if you're planning on selling across state lines, then it may be registered with the U.S. Patent and Trademark Office. Although registration is not essential to protect your trademark in the United States. what registration does is it greatly enhances the legal protection for the trademark owner. It usually gives, again, those statutory damages. And in fact, if you register with the federal U.S. Patent and Trademark Office, that's when you usually will apply the R in the circle. That means it's registered. However, again, protection does not have to be afforded through registration. Once you begin using the trademark, you've used the trademark in commerce, you're usually afforded common law trademark rights. I do encourage you to use, in conjunction with any of your trademarks, that the TM that's in the circle. And in fact, if you anticipate that you'll be registering your trademark federally, usually they're going to require you to have used the trademark in some commercial marketplace for a good period of time, so that it becomes actually a mark that's associated with you, right, with your business. And then so in that instance, you want to prove that you've alerted the public and the marketplace that it's your trademark. So you've applied that TM in the circle next to it. And then once you register it federally, again, that's when you can start to use the R in the circle. So there's links here again about how to search through the U.S. trademark database, which is something that you'll definitely want to do before you attempt to register your mark, to make sure that you're not infringing on anyone else's trademark, and also that your logo is not too similar to someone else's, in which case you may be denied registration. So you can check that yourself, or you can have your lawyer check the registry, the database. Sometimes a good start is just by doing a Google search, and you'll find that maybe there is somebody else who already is using the mark, in which case you might want to do a little more digging in the database and see if it's actually been registered. And then when you're ready to file your trademark, there's also, of course, an online application portal, and there's a link to that there, and you can take a look through the different requirements. Registering trademark is a little more complicated than copyright, only because there are different criteria, different categories, for marks. So you want to make sure that you register your trademark to cover as many categories as you think you'll need for whatever product it is or service that you're offering. And an attorney can certainly help you do that. The fees for registration, I get asked about that a lot. That's something that does change somewhat, and you're going to want to look specifically at the application system to find out about the fees. So if you're using social media for marketing, it's really time to take a hard look at your company's online footprint. And I leave this slide with everybody to come back to and do a check through. Make sure that you're conducting an evaluation that's going to help reduce the risk, and make sure that you understand your company's exposure when you're using social media for marketing. Okay, so if you want more information on trademarks and copyrights, I'm going to recommend 2 additional sources or resources. The first is the Women in Ag. They have a terrific webinar about using digital images. It's posted, I think it's still on the site. It covers the federal copyright laws and how not to run afoul of them. It also provides information about how to protect your own images from infringements on your copyrights, and I really commend it to you. It also reviews you can review the publications that are listed on the web page, and again, those links are hyperlinked on my slide. The links to the webinar and the publications, and I'm happy to send anyone, again, a digital copy of my slides if that's helpful. I also recommend, if you want to learn more about trademarks, watching the YouTube video from the Conservation Law Foundation. It's called Protecting Your Intellectual Property as a Food Entrepreneur, but it really applies across the board. They explain the differences and strengths of trademarks that you want to think about when you're designing a mark so that it's afforded the strongest protection, and also how to do a trademark search, how to register your mark, and protecting your mark and enforcing your trademark. They also cover copyright protection as well, so I commend those resources to you. Okay, so remember that the second thing that you need to pay attention to is privacy of your customers' personal information, and also protecting the data that you're going to be collecting by virtue of interfacing with customers online. So by the very nature of being online, you're collecting data, and you're going to have some responsibilities with regards to safeguarding that data. I want to start with an all too common thorny legal issue that a lot of businesses wrestle with, farm businesses in particular, when and how they use pictures of people having fun at their U-Pick farm or enjoying milking the cows at their agritourism farm, whatever it might be. If you want to cover your bases for utilizing photos of customers or people who attend an on-farm event, I want to make sure that you clearly post signs and consider having your customers even sign waivers that say that by attending the event, they are implying consent for you to use pictures of them, unless otherwise documented somehow. Taking photos of customers and sharing the photos on social media sites is fairly low risk. However, the more places that you share the photos, for instance, in a blog post or some other promotional material, the higher your risk becomes as more and more people start to view that image. There also tends to be more backlash when the photos include children. So with pictures of customers, the potential legal issue is that unlike a street parade or some other public setting, people coming to your farm may feel some level of protection from having their whereabouts or their personal activities known by being photographed. And they may be so concerned about it that they may file a lawsuit claiming that you invaded their privacy by taking and posting their pictures. Or if the customer has some notoriety, they might claim that you misappropriated their likeness for your benefit by posting their photo. Most states allow those types of tort claims, the invasion of privacy and the invasion or the misappropriation of likeness. And even though it might be very difficult for someone to prove that they were damaged as a result of your using their photograph, you don't want to have to go to court to figure that out. Also, outside of the legal risk, especially when we're talking about posting pictures of children, of course, there could be concerns from parents or from anyone really who has some self-protection reasons for not wanting their whereabouts to be publicly known. So the way to avoid those entanglements is to post those signs, and I would suggest having people sign waivers saying that they consent to having their picture taken and possibly used in advertising for your farm. Okay, so now looking at collecting and protecting the information that you get from online customers. So it may seem simplistic to point out that before you can send marketing emails or messages, you need to collect the contact information of your customers or potential customers. Yet the actual process of collecting the information is really far more complex than it seems, particularly if you're trying to collect it in a legally compliant manner. So most jurisdictions around the world have privacy legislation in place that requires you to notify people before you collect their personal information. The laws are different, of course, across the country. You should know that in the U.S., across the world in different countries, but you should know that in the U.S., traditionally, two bodies have acted to protect the rights of those online. One is the Federal Trade Commission. The other are state attorneys general. But there is really no overarching privacy law that applies to the collection of data. So what you might need to do is look into each of your state's laws individually. And what you'll see here, especially for people who are already selling online, you really should be aware that California has a piece of legislation that covers online privacy in particular. It's the California Online Privacy Protection Act, and there's information about it here in the slide. It requires that you need to disclose various things, the kinds of information your website or online marketing tactics collect, how the information is shared, how customers, the process that your customers can follow to review and change the information that you have about them, etc. So how exactly do you go about informing people about how you're collecting and protecting their data? Well, there's a list, there's a to-do list. The first is you want to set up a privacy policy on your website. And again, you may have checked out privacy policies on other people's websites, other businesses' websites that you may use. And I'll talk about the privacy policy in a second. You're also going to require your customers or website users to agree to your privacy policy when you collect the information from them. And I'll talk about that in a second. Once you've collected the data, you have to make sure that you keep it with a reputable cloud storage provider so that it's protected. And then you also want to protect yourself from liability in the case of a data loss, in particular a breach probably of the cloud storage providers. So to make sure that your customers or your users' agreement is going to stand up legally, I usually recommend that people use a click wrap method. And most people are familiar with this. A click wrap method is where your customer your customer or user has to actually click the words "I agree" to your privacy policy in some way. And this could be when they sign up to receive your marketing messages or your newsletters. or maybe when they make a purchase on your website. And what you see here is one example, but you can find them, of course, all over the web these days in particular. They're very common on websites. One simple way to protect your customer privacy when you collect information is to use security mechanisms such as a secure sockets layer or an SSL. SSL means that the connection between your website and the user's browser is secured through encryption when data is being transmitted. It ensures that any websites that you use with your customers, or you want to ensure rather that any websites that you use with your customers has SSL enabled. Another potential security issue is the storage of customer data. A popular way for many online businesses and marketing companies to store data is to use cloud storage providers. To reassure your customers that you are keeping their data safe, you always want to choose a reputable provider, and preferably choose a reputable provider within your own jurisdiction. And this is because some jurisdictions have legal requirements that data should either not be transferred out or must be accessible even if it's stored overseas, or should be transferred only to jurisdictions with similar legal protections for the data in place. So that's something that you're going to want to check into. If you overlook this fact and store data with a cloud storage provider in another jurisdiction that has inadequate protections, you may be in breach of your local laws. And I wanted to point out just the example here on the slide is from Google. They actually list here all of their protection mechanisms that they have in place. They're using the SSL links. They're offering two-step verifications, and all of the various other measures that they take. So that's one example of how they inform their users of their data privacy collection and storage mechanisms. If you use a cloud storage provider, you need to ensure that your privacy policy and or your website terms of use cover the situation in which that cloud storage provider has a privacy breach and your customers' data might be released. So the example here on the right is an example from Amazon, and as you can see, that clause that's highlighted there specifically limits Amazon's liability and includes no liability for loss of any files. And you want to ensure, here what you're doing is you want to ensure that you're not liable if a third party, the cloud storage provider, has a data leak. So to maintain customers' trust, use only reputable providers, I can't say that enough, and be transparent about whom your customer data is stored with. And then should a breach occur, you want to make sure that your customers understand that you're not going to be liable for release of their personal information. Something else to be aware of is that most states have laws like Maryland's law that protect employees from having to give their employers access to their personal social media pages. And a lot of times people don't think about this. What I have on here is information that you can review. It's specific to Maryland, but Maryland's law is very similar to other state laws. Again, you can't require your employees to give over their access information for their personal accounts. However, of course, if they have use of or access to or in somehow control of your Facebook posts, your whatever your social media pages or your website might be, maybe one of your employees is your webmaster, obviously their account login information for your business needs is something that you can have access to. And then also, of course, there's laws that restrict what material and information your employees can take from your business. I want to point out here that there is a link in my slides to this social media privacy legislation guidebook, which is a really good guidebook on the rights and responsibilities of employers with regards to privacy and social media and their employees. Okay, because this is a webinar about advertising on social media, we of course have to talk about how to handle negative reviews or comments that people might post. Bad online reviews are not an if you're a business online, but really rather a when. So every business eventually faces a true test in reputation management. And the first thing you want to remember if you get a negative review is that you don't necessarily want to delete all of the negative reviews or comments that you might get. Reviews give you the opportunity to address any bad vibes that might be out there. Plus, it looks a little fishy sometimes if all you have are rave reviews. Allowing all voices to be heard certainly helps to minimize your risk of being accused of false advertising, which I'll talk about more in a bit. So the first step, there's 5 steps really that I outline here. The first step is just take a deep breath. If you get a negative review, collect your thoughts. Negative reviews or comments are part of doing business, certainly part of having an online presence. Your reply to that is going to be very powerful, however, and you want to take your time to consider whether and how you're going to respond. Secondly, I would say investigate the issue. Make sure you find out whether that bad review was warranted. If the review is completely fraudulent, you should know that there are ways then for you to have to follow proper channels to take the review down if it's on a different site, for instance, Yelp. And the links here on the right go directly to the pages for those platforms that tell you how to challenge a review that might have appeared on those platforms. The third step is a bit tricky, but you can certainly reach out offline. You certainly don't want to have an ongoing dialogue with the person who left a negative review. You don't want that to be online. So if you're able to contact the person who left the negative review offline, you can reach out directly to him or her, but there's cautions to take with that. You can certainly come back and read through this. I would suggest that reaching out to somebody directly is really only an option if you assume that the complaint itself, what they're complaining about, doesn't raise any possibility of the person possibly filing a lawsuit. Or in other words, it's not a complaint that the person was injured somehow as a result of your product, or that you reneged on a contract agreement, something like that. It's only a real option also if you can legally obtain that person's contact information, right? So they wouldn't be surprised that you contacted them. They would know that you had their contact information. And also that you understand that the person might not be willing to talk to you or may even be hostile towards you, and that might intensify their online harassment. So you just need to keep those cautions in mind if you decide to reach out online. But it is an option. And then the fourth step is possibly to respond with a public apology. So if the person has removed their negative review, you can skip this step, obviously. But if they haven't removed their negative review and you've come this far, it may be time to respond publicly. So it's your opportunity then to share your side of the story with the public. And there's some guidelines here for how to do an apology. Things you want to keep in mind as you're crafting the apology. You always want to tell the truth, make your apology sincere, and don't use a canned reply, which are things that people on social media can pick up on pretty quickly these days. The last step is to go back and build a process to avoid any future mistakes that might have happened, right, that brought about the negative review. The one thing I want to point out here is that companies do have ways to protect themselves from inappropriate or irrelevant content. And the law says it's okay to prohibit or remove a review that contains confidential or private information, for example, anybody's personal financial, medical, or personnel file information that might get posted, or a company's trade secrets that might get posted. You can take that down. You can take down reviews or comments that are libelous, harassing, abusive, that use obscene or vulgar or sexually explicit material, or is inappropriate with respect to race, gender, sexuality, ethnicity, or any other intrinsic characteristic of people. You can take down reviews or comments that are unrelated to your product or your services. So, for instance, somebody made a mistake, meant to leave a comment about a different company, but they left it on your page instead. And you can take down comments that are clearly false or misleading. But I do want you to keep in mind that it's unlikely that a consumer's assessment or opinion with which you might disagree is going to meet that clearly false or misleading standard. That's really going to identify false statements of fact. Okay, I'm moving pretty fast, but lastly, we're going to go over the third thing that you need to consider if you're going to be advertising online, and that is the rules and regulations of the Federal Trade Commission and other consumer protection bodies concerning advertising. So let's begin by talking about two common advertising tools that marketers use: product endorsements and running contests to boost traffic to websites or social media pages. Let's start with product endorsements. I'm sure everyone is familiar with the way that advertisers use endorsements to sell things, like such and such product is used by Beyonce, or someone is quoted as saying how such and such product changed their lives. Well, the Federal Trade Commission conducts investigations and brings cases involving endorsements made on behalf of an advertiser under Section 5 of the Federal Trade Commission Act, which actually prohibits deceptive advertising. So truth in advertising is important in all media, whether they've been around for decades like television and magazines, or they're new media like blogs and social media. An endorsement must reflect the honest opinion of the endorser, and it can't be used to make a claim that the product's marketer couldn't legally make themselves. They can't say something outrageous if you can't. When bloggers and others write online about products and services, disclosure is key, and that means that they need to disclose if they happen to be family, or they're an employee, or they were paid, or they received some free items by the company and then wrote about those items. That relationship must be disclosed in a way that's clear to the reader. The Federal Trade Commission has revised, in fact, its endorsement guides to include social media to make sure endorsements are honest and not misleading. And again, there's a hyperlink here to the new guides. The guides are intended to give insight into what the FTC thinks about various marketing activities involving endorsements and how Section 5 might apply to those activities. The guides themselves don't have the force of law, you should know. However, practices that are inconsistent with the guide may result in law enforcement actions alleging violations of the FTC Act. Law enforcement actions can result in orders requiring the defendants in the case to give up money they received from their violations and to abide by various requirements in the future. Although you should understand there's no such thing as a fine for violations of the FTC Act, but you might be required to disgorge profits made through violations. So marketing and advertising on the internet is subject to the same laws as advertising on any medium, but there are some particular things that the FTC wants you to do if you're advertising on the internet, and they're listed here. And the first really has to do with making the disclosures. They want to make sure that those disclosures are inserted in close proximity to or on the same screen as whatever is the claim that's being made. They want you to use graphic cues to encourage consumers to scroll down to see the disclosure. And they want you to make hyperlinks that lead to disclosures that are obvious and properly labeled, as well as using an absolutely consistent style so that people can find those easily. And there's a guidebook here on advertising and marketing on the internet that's put out by the FTC, and is hyperlinked in my slide. Another practice to be aware of in social media is the contest. Social media contests have become quite popular among companies, again, trying to build awareness of their brand. Where this can be dangerous, however, is that there are a wide variety of laws pertaining to contests across the United States, and it's state-specific. Some states prohibit certain types of raffles, others require that giveaways involve games of knowledge, not chance, and others actually may require a gambling license to run the contest. So unfortunately, with the multi-state and multinational nature of the internet, you could easily cross borders, particularly in social media, and inadvertently run afoul of the laws across different borders. I think I want to encourage you to be sure to check with an attorney who's experienced in internet law before you might consider running such an event. The rules and regulations of the FTC and other consumer protection bodies, in general, the FTC wants to make sure that that there's not unfair, deceptive, or misleading advertising happening. That's what's prohibited under the Act. And that means that any marketing must tell the truth and cannot leave out any relevant information that a consumer would be interested in. If claim can be misleading, if relevant information is left out of the claim, or if the claim implies something that's simply not true. You also need to understand that there are other regulatory bodies that look in on advertising, and things to keep in mind are the Advertising Self-Regulatory Council, which governs National Advertising Review Board, and the Children's Advertising Review Unit. If any of your marketing is targeted at children, you need to ensure that you're fully aware of the Children's Advertising Review Unit guidelines, and there are links then again to that information. If you do get into trouble with the FTC or any other consumer protection body, make sure that you're prompt, you're clear in your communication with them. Of course, I'm going to recommend that you seek out to an attorney before you respond to them, but your response should be prompt. You want to really aim to work together towards a solution right away, as that may help you avoid prosecution. Okay, additional considerations quickly for online direct sales. We have farmers who, again, are doing online direct sales to customers. The considerations include the technical infrastructure that you have to have in place to do those sales, state-specific labeling laws, sales tax collection that you may be required to do, and food safety recall notices. So the internet can certainly be a great way to increase farm visibility and for local marketing, but you can also sell directly on the web to consumers, shipping them products or offering pickups. One advantage of using the internet for supplemental sales is that you may attract customers who lack access to your products in person. If you have a high-end specialty or an alternative product, customers may be willing to pay for the relatively high cost of shipping, in fact. Or you might choose to wholesale products to restaurants or other high-end outlets who can purchase the item in bulk because, of course, bulk shipping is much more reasonable in cost. Another option is to consider offering deliveries of products sold online, either directly to consumers or to restaurants or food co-ops and chefs. If you're selling your product online, there are going to be these basic pieces of infrastructure that you'll need to develop. You need to develop a website, and then you're going to have to look into all of those guidelines that I talked about before about having a website. You want to look into what kind of shopping cart software you're going to have. Anytime you sell something online, it's more complicated. That's more complicated than buying one single item. A shopping cart helps, and you want to check with your website hosting company to see what maybe they offer for your shopping cart. You're going to need a payment processing, whether it's PayPal or a credit card processor. Somehow you're going to have to be able to process payments online. And email support. You need to have an email address where customers can contact you if something goes wrong. They want to change their order or they want to return something. And a lot of times, in fact, your state laws are going to require you to have an email and other contacts clearly visible on your internet site. Additional considerations for online direct sales, like I mentioned, include state-specific labeling laws. You need to look into your state's labeling laws or those states where you plan to be selling product. I'm going to point out California in particular because California is very aggressive in its labeling requirements. California Proposition 65 a couple years ago passed. And the warning label requirements went into effect in 2018. And as you can see here, these are just some examples of the new requirements that if you're selling product in California, whether it's food, whether it's handbags, wallets, belts, whatever it is, there are labeling requirements that must be on those products. Also, you need to understand that you may be required to collect sales tax. Last summer, the United States Supreme Court ruled that out-of-state sellers, including online retailers, will be required to collect sales tax if their business meets certain economic thresholds within the states. So what this really means is that certain states have laws on the books. Many of them are already in place, and by their plain language, they're going to require that you, by the plain language of the law, it's going to require online marketers and sellers to collect taxes if they sell a certain quantity or a certain dollar amount or a certain number of products into that state. And you need to make sure that if you're selling into those states, you know which states you need to collect sales tax for. The other thing that I want you to be aware of is that the FDA, as most people know, does have mandatory recall authority through the Food Safety Modernization Act. But it also recently published guidance explaining that the FDA does intend to disclose retailer information for certain food recalls, including foods purchased online, in order to inform retailers and consumers about recalls of foods purchased online. And again, I have links to that new guidance, but that's something for online sellers to be aware of. Okay, so again, if you have questions and you want to talk about the specifics of your marketing or online sales plan, please talk to an attorney. And there's actually here a link to our website for ALEI that will then send you on our resource page to the directory for attorneys that are in the Delmarva area. And I think that's it. So my email address again is nlcook@umes.edu. And I'll go ahead and take this out of presentation mode so we can talk about questions.
All right, Nicole, and you do have a couple questions. The first is, California OPPA the most strict policy among the states, and so should be followed by us in Maryland?
I'm sorry, could you repeat that?
Yeah, so you were talking about the OPPA,
yes,
California, and that they have the most strict policy among the states. Is that what we should be following in Maryland?
Oh, well, I think it's...
Is that...
I'm getting some feedback. Sorry. I think the question is asking, you know what? I'm sorry. I'm trying to do like technical things while I'm answering this. I'm going to stop sharing my screen now, Shannon. Is that all right?
Yeah.
Okay. So I think the question is asking if you're if you're in Maryland and you're selling products that you anticipate might be sold in California, which it might likely would if you're online, right? Or could. Then yes, that product, if it's going into California, it does have to follow California's labeling laws. Now, if the question is asking whether Maryland should follow suit and also require the same labeling laws, I don't think that's something for me to delve into. Does that make sense?
And if someone endorses on our social media the product as a cancer cure, we need to take that down?
Unless it's a cancer cure, yes. No, I don't mean to be flip, but yes, that would be a really good example, and we see that happening a lot. You know, again, such and such product is, you know, cures whatever. Unless you can substantiate that claim through science and research, and you can, you know, advance that claim, then yeah, that would be something that if that's found on your page, especially if you know, a lot of times it appears on your page, and of course we instantly like it, right? We like that comment was made.
Right.
And so if you like it, that really is then deemed your endorsement of that claim. And if that's a false claim, that's gonna impact you.
Okay. All right. Those are the two questions that were typed during the presentation. If anyone else has other questions that they'd like to ask Nicole, please put those there in the chat pod. You can send it to her, myself, or all attendees, and we can answer some of those questions. Nicole, that was really great. Excellent information, and something that I think that, you know, when we jump on social media, it's really easy to forget some of those type of things. You know, different from when we're writing papers or things like that. So thank you very much for your presentation.
Sure. Thanks for having me. Again, just things to think about. Nothing, I don't want to scare anybody away from using social media. It's a really good marketing venue, but just things to keep in mind.
And we'll just give it a little bit longer, see if anyone's going to put a question in. Thank you, everyone, for attending today. We really appreciate it. Again, this will be recorded or has been recorded and will be sent out. The link as well as the materials. Nicole, you'll email me your presentation.
Yep.
And we have a bunch of future presentations coming up on a variety of topics. All right, Nicole, I don't see any, so I'm going to go ahead and stop recording here.